Today, we're going to be talking about timelines on the contract. We're going to talk about how that can affect your buyer and what could happen to their deposit.
Having an attorney involved in any real estate transaction is the most prudent way to move forward with a real estate transaction, because no, you don't need an attorney to be involved, as a title company can simply close a transaction. But in the event there's an issue, it's always smart to have an attorney, a law firm, I wouldn't even say an attorney-run title company, but a law firm in place to deal with any issues that may arise during that transaction is super imperative for everybody.
What happens when a buyer doesn't give their second deposit? Once you give the loan commitment, whether it has conditions or not, is there anything that can supersede for the buyer to still get out of the deal? We've talked about several steps of the contract. The main things are: what's your closing date? How many days do you have for inspection? When do you need to be requesting your repairs in your inspection? And when do you need to cancel? Just requesting repairs doesn't okay to go past the inspection date, so get an extension if need be. And then we have something else called the loan commitment date. Hi everyone, welcome to Making Money with Laura Sanders, and I am your host, Laura Sanders. Every week we talk about something that will help you make a little money, save a little money, or maybe just help you navigate this crazy world that we live in. Today we're going to be talking about timelines on the contract. We're going to talk about how that can affect your buyer and what could happen to their deposit. So I have Nick Fiorello here with us today, JK Closings Attorneys, and we're going to talk about how do you not jeopardize your client's money. Welcome, Nick.
Hi, thank you for having me.
Thank you for being here. So I know that we always call you all the time and we're like, what about this scenario? What about this scenario? And that's the number one thing that I say, that dealing with a title company that's attorney run is a big deal. So, as a realtor, I highly recommend that. And, I think that agents are a little lackadaisical, and I feel like the real estate industry is a way different world than it was way back when I first started a million years ago. So let's talk about dates and times on the contract.
Definitely. I mean, the contract, well, first of all, having an attorney involved in any real estate transaction is the most prudent way to move forward with a real estate transaction, because no, you don't need an attorney to be involved, as a title company can simply close a transaction. But in the event there's an issue, it's always smart to have an attorney, a law firm, I wouldn't even say an attorney-run title company, but a law firm in place to deal with any issues that may arise during that transaction is super imperative for everybody. So that's number one. And number two, like what you were saying, time. Time is a huge, very important topic and item of the contract. The contract explicitly says that time is of the essence in this contract. And it highlights, the fact that calendar days are used, not business days. And that means items and deadlines must be completed and met timely. So, okay, you're talking about meeting things timely.
There's a couple of bullet points in the contract, right? First bullet point is what's your closing date, right? When are we going to close?
Definitely.
Now, when people come from New York, a lot of times their idea of a closing date is on or about. And that's not how it works here. It is a factual date that is put on the contract. So if an agent puts on or before, it's not like the agent can go ahead and call to say we're going to close before. That has to be agreed upon between both parties.
Definitely. If you have a closing date, the contract says on blank. And then if you put on or before, if you write that in, you still have a date. And if you're closing on or before that date, it's imperative to get an agreement signed by both parties acknowledging that.
Yeah, and you're pretty big on that.
Not only, definitely.
Adding those addendums all the time.
It's clear for everybody.
Yeah. So definitely. I guess it doesn't even make sense to even put on or before. Should just have a date.
Should just have a date. And then, there's a lot of different moving parts. You might have a lender, you might have a moving date where the seller has scheduled movers where they can't move it forward. Maybe the moving company is already booked out. Maybe all moving companies are already booked out. Then you have to get into language about post-occupancy agreements and, different complexities like that. But if everybody's clear on a closing date that is specifically laid out, then everybody has that target goal in mind, including the lender, both buyer and seller, the agents, the closing agent who's handling the transaction. And like you said about New York and New Jersey and a lot of northeastern states, it's a lot more fluid. And we have these issues all the time where we have to clearly lay out that there's a specific closing date and that time is of the essence. And, especially with all the other deadlines in the contract, which I'm sure we're going to talk about shortly, the inspection period, the loan approval period, a lot of those deadlines are not time is of the essence and are a lot more, I don't want to say lackadaisical in other states, but a lot more liberal in terms of the deadline and the ramifications of not meeting those deadlines.
Why do you, and I'm always curious about this, and I'm from New York, right? But why do you think that New York contracts take so long to close?
I'm not sure, everybody seems to point to the fact that they need an attorney to close. And those attorneys are the ones that slow things down. So when they come down here, they have that misconception that attorneys are going to slow things down. And sometimes they do when it's a litigation focused attorney and they're not focused on closing, they might slow down a transaction. But when you have real estate attorneys that are focused on closing, such as our office, we're focused on closing as efficiently as, and I wouldn't say as quickly, but as efficiently as possible.
Right. So you mentioned inspection. So that's another thing. So this one cracks me up all the time with agents because they'll put down 10 days. The first thing that some people are not sure about and make mistakes is it's calendar days, not business days. It also, when do you count day one? So if I sign, go ahead.
The day one is the day after the effective date. So if you have a buyer that signs an offer today, today's the 20th, then you have a seller that signs tomorrow, the 21st, and the date on line 45 of the contract allows for to be executed by tomorrow. Then you have an effective date of when it is delivered to both parties. That would be your effective date. And then day one would be the following day. So in this example, tomorrow would be the effective date. Day one would start the following day.
So a lot of people have misconceptions that, if it, like, you wouldn't count Monday. Like, let's say you had a 10-day inspection starting today. They would think that, Monday's a legal holiday. You wouldn't count Memorial Day. But that's not true. You would count it. Now, if it fell on Memorial Day, then it would move to the next business day. Or
exactly.
if it fell on a weekend, it would move to the next business day. And it falls till, it used to be 6 p.m. Now it's 11:59 p.m.
Yes. So this is a good example because we have Memorial Day coming up. If you have a effective date starting today, and so today is Tuesday the 20th. So if you have a effective date of today and a 7-day inspection period, that means that inspection period will expire next Tuesday, not Monday, but Tuesday. Monday is a national holiday. But since it falls on Tuesday, it will stay on Tuesday, and it expires at after 11:59, after the turn of the day. So at midnight, that's when it turns, and then the inspection period would run. But if it were to fall on Saturday, Sunday, or Monday now, because Monday is a national holiday, then it would move to Tuesday.
Till 11:59 p.m. So here's another one that gets me. You ask me for repairs. You say to me, Laura, I'm buying this house on Adams Street, and I really want you to change out the water heater, do this, do that. And you say, Okay, well, I'll talk to the seller. The seller never gets back, and the contract is expiring tomorrow at 11:59 p.m. and the following day comes. So tomorrow's Wednesday, 11:59. Thursday morning comes, and the agent didn't cancel, and the agent didn't put anything, like nothing was signed to agree upon those repairs. Then the agents are like, oh, well, we're going to cancel. You've already missed your window to cancel.
This is a common error that happens.
They think because they've requested, they feel because they've asked that supersedes. I learned the hard way on this, where I had a seller say that he was going to go ahead and sign an addendum to do a flat roof. And he hadn't signed yet, and the inspection period was expiring. And I said to the buyer, don't worry, the seller said he's going to do it. Then the next day comes, and the seller says, oh, my attorney says I don't need to do it. They've already passed their inspection period. Yeah, but you verbally told me you were going to do it. Like, I'm your agent. Like, that's crazy, right? But if you're another agent having the buyer asking me for repairs, and you haven't canceled the contract, so the buyer's got to know how they really want to negotiate, right? The buyer needs to know how strong-willed are they? Do they want to lose the property? Because you need to say, in writing in an email, doesn't have to give the addendum. It just has to be in writing saying, not via text either. It needs to say, we want X, Y, and Z done. If that's not done, then we're canceling the contract.
Yeah, and I would even go another step on top of that and provide a release and cancellation with that email stating that, look, I'm asking for these repairs. If the seller is not going to honor this request, then please let this email serve as notice of the buyer's termination of the contract. Please see attached release and cancellation. Please return it at your earliest convenience.
Right. Which you don't have to send the release and an email is good enough, but I know you and
it's
your
just another layer of protection.
You're very big on the addendum. So, like,
hey,
let's go back. Yeah, let's go backwards, right, for a second. You talked about quickly about the effective date, right? And if I say I'm sending you an offer, and the offer is going to expire tomorrow on the 22nd of May, and the seller doesn't sign till the 23rd of May, Mr. Nick Fiorello wants an addendum stating that the effective date is the 23rd because the contract said it needed to be signed by the 22nd.
Although there's an argument both ways. You can argue that both parties are in agreement. They move forward. As long as the offer wasn't rescinded any other way, both parties have a mutual meeting of the minds. They want to enter into the contract. They enter into the contract and they act as if they are under contract. Yeah, you can argue that. But why would you want an argument when you can have it clear as day in an addendum stating that both parties agree that the effective date is now the 22nd, not the 21st? Right.
And then could you then say that the contract's null and void, that it really wasn't a binding contract because it wasn't executed during the time that the offer was realized?
You could argue that. The contract specifically says, if not signed by buyer and seller and an executed copy delivered to all parties on or before the date provided, this offer shall be deemed withdrawn and the deposit, if any, shall be returned to the buyer. So that would mean that there is no offer to be accepted. But then if both parties do move forward as if the offer was accepted, then there is
like starting inspections, things like that. It's assumed then.
Exactly.
But if it came back afterwards and the buyer never did anything, and you say, yeah, I had my deposit, but I told them it expired on the 22nd, and now it's the 23rd, the title company would say, okay, and we're going to give him back his deposit. Unless you can prove
the contract. Yeah, unless you can prove what you're saying. If they move forward as if they're under contract, but the contract explicitly says that the offer that the buyer provides forward, if not signed and returned to both parties and signed by both parties, that offer is withdrawn.
Right.
So then the buyer can stand on that and say, look, the contract says you had until today to sign it. You did not sign it. My offer is deemed withdrawn. Obviously, they can go in objection to that and move forward as if they're under contract. And that's where the seller can argue, hey, you're moving forward as if you're under contract. We've done inspection, we've had an appraisal, we've done whatever. You can't now pull that card,
Right.
because there was a meeting of the minds.
Right. Okay. That's good to know. And I think this is like really good information. And I think it's very clear and concise the way that we're walking through this. But we're going to go to commercial break. And when we come back, we're going to talk about the part that really gets people all tied up. Like, do you need a clear to close before providing a loan commitment? Like what's really required? People asking for an extension after extension. Like, what does that look like? So we're going to go to commercial break. And when we come back, we're going to go ahead and talk about this.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
At JK Closing Attorneys, we do all of the same things that a title company does, but with the benefits of being a law office. We can help with residential real estate, short sales, commercial real estate, refinances, 1031 exchanges, and FRIPTA withholding.
Contact JK Closing Attorneys today at 954-332-3111. Again, that is 954-332-3111.
Hi, everyone. Welcome back to Making Money with Laura Sanders, and I am your host, Laura Sanders. Today, we're talking about timelines on the contract and really trying to help agents to stay out of hot water because these mistakes can cost your clients money. So we've talked about several steps of the contract. The main things are, what's your closing date? How many days do you have for inspection? When do you need to be requesting your repairs in your inspection, and when do you need to cancel? Just requesting repairs doesn't okay to go past the inspection date, so get an extension if need be. And then we have something else called the loan commitment date. But actually, before we jump to loan commitment date, let's talk about what happens when a buyer doesn't give their second deposit.
That would be a default of the terms of the contract. If there is a requirement for a second deposit, and the contract provides a timeline, the exact day amount, which we talked about earlier, how you start counting one the next day after the effective date. Usually I would say 10 days is a good number for the second deposit. It's usually 10, 14, 15 days, something like that. But it can be anything that's provided in the contract. If that second deposit is not made by that date, then the buyer can be held in default of the contract.
Okay. So the buyer being held in default of the contract, how do you move forward from that? Like, do you have to stay until the closing date? I mean, or you give them notice?
So at that point, it's going to be up to the seller whether they want to try to claim the deposit. So the seller has a couple different options. They can hold the buyer in default, they can claim the deposit, and then you're up in limbo. For
what does that mean? You're up in limbo?
The seller can't just take the deposit. If the buyer is not willing to give up the deposit and the seller wants to put a claim on the deposit, then the seller would have to put in a formal claim. And then per the contract, it provides for dispute resolution. Both parties have to attempt to mediate first before a lawsuit can be filed. And then if they're going after that deposit, they don't agree to a release before the mediation, or they don't really agree to a release during the mediation, then they would have to litigate over the matter to determine where that deposit would be going to. And then that would require a lawsuit between buyer and seller, or seller and buyer, in court to determine who is owed that deposit, whether it goes back to the buyer or the seller. If there's a breach of the contract, obviously that would be taken into account, but then both parties would have to pay for legal fees. It would be, unless the deposit's substantial, they might not walk away with any bit of the deposit.
So, but can the seller put the house back on the market during this time?
It depends. So if you, a couple things. So I would like to say that if the buyer missed something and it's curable and it could be cured and the seller would like to close, then no, obviously you can reinstate the contract and move towards closing. This is obviously the less litigious way of thinking, trying to come to a resolution. It's a lot easier than finding another buyer, trying to claim a deposit, and muddy the waters that way. If the buyer is in default and they've made it clear they're not going to close, then you can relist the property. But a lot of the time, I don't want this to get misconstrued, because a lot of the time there may not be a default until the actual closing date. So a lot of the times they meet all the obligations of the contract, all the terms that we've talked about, and then we catch wind that they might not be able to get the loan or something after the fact they've gotten loan approval, or if they didn't provide the notice we're about to talk about, and they're not able to close. So in that case, there's no default yet until they cannot close on the closing date. So in that instance, you cannot relist the property until they're actually in default.
Okay, I see what you're saying. You got to wait and see if the closing date comes and goes.
In that scenario, and another scenario where they're actually in default, then you don't have to wait until the closing date.
Okay, so let's go to the loan commitment. Okay, the loan commitment is due anywhere from 20 to 30 days from the time that you go to contract, right? Again, calendar days. Sometimes, like I had one deal recently where they said that they needed it to be clear to close before they would give the loan commitment. And they kept asking for extension after extension. A loan commitment can have conditions on it, correct?
Yeah, so when we get a loan approval, the loan approval may still very well have conditions on it. When I'm looking at a loan approval issued by a lender, they're always going to be conditional. There's never going to be a final loan approval given before closing. They're going to be conditional. They're most likely going to have a couple of conditions left. And it really depends on those conditions as to how serious and how shaky that loan approval could be. If there is an outstanding appraisal and the house might have been listed a little high, there might be a worry that they might not get loan approval after the lender issues that conditional loan approval.
Now, I think that's a different story, right? If your appraisal hasn't come back and you had a 15-day loan approval, if you had a 21-day loan approval, you damn should have had your appraisal back by now. I'm sorry.
Definitely.
Right? But once you give the loan commitment, whether it has conditions or not, is there anything that can supersede for the buyer to still get out of the deal?
Yeah, one, a seller default, or if the seller doesn't close. And two, property-related conditions of loan approval. So
insurance?
Insurance, yeah. If there's some reason that
really you shouldn't have insurance
to the property.
Wait, you shouldn't have insurance before you get to that loan approval period?
You should, but there might be something that comes up where it is a property-related condition that insurance cannot be obtained, which means the loan cannot be obtained, and then that can fall back on property-related conditions. Property-related conditions are a very vague term of the contract. They're not very defined. Mm-hmm. But if it can be related to the property, this happens with condos a lot, where there's something to do with the property, where they can't obtain insurance or the lender can't issue loan approval after they have issued a conditional loan approval, that may be a way for the buyer to get out of the contract. But those are the only two ways, that and seller default.
Okay. Well, we're almost running out of time here, but so to recap, right, mainly right now on this part, I had a situation recently where the buyer lost their, we went for 45 days. We got the loan commitment, and the Friday before the Monday we were supposed to close, basically said that that they were no longer an American, they were no longer had their green card. It expired a year ago. How you go out and buy a house without your green card, I don't know. But nevertheless, the seller lost 45 days. The agent sends out the denial letter, and I said, you gave a loan commitment. So how can, and why is it so hard to get these deposits? And you got like less than 60 seconds to tell us that. But like in these particular instances, it should be released automatically to the seller. They defaulted. They had loan approval.
I agree, but the contract doesn't provide for that. It provides that the parties must try to mediate, and after mediation, if they don't come to an agreement, which most of the time they do, if it even gets to that point, it would have to be litigated over. And
what does mediation cost?
Mediation cost, it depends, anywhere between 500 to 1,000, I would say. The parties have to split the cost of the mediator. Usually I've seen $500 for the first hour and $250 for every hour after that. So you're looking at, if it's an hour, then you're looking at $250 for the mediator cost plus any attorney fees if you're represented by an attorney there.
Wow. Well, what's a good way for people to reach out to you if they're looking for an attorney that can do their closing for them? Or
you can call or text. You can call or text our office at 954-779-5000, or you can shoot me an email at nick@jkclosings.com.
Well, thank you so much for being with us. And if you're looking for a top agent, you want to make sure your house is getting sold, want to make sure it looks in its best light possible, I'm definitely your girl. Give me a call, Laura Sanders, Remax Direct, 954-650-0827. And until next time, make it a great week.